Hey everybody, Knox here with the American Suppressor Association, and we've got some exciting updates on Anderson v. Raoul. That's the ASA Foundation and Silencer Shop supported lawsuit challenging the suppressor ban in the state of Illinois. We're joined today by our General Counsel, Michael Williams. Michael, how are you doing today, man?
Doing well, Knox. Thank you for having me.
Yeah, thank you for joining us. So tell us what's going on in the case.
So, as we mentioned last time, our case is before Judge McGlynn in the Southern District of Illinois. Um, we got a couple updates for you. So, on April 5th, 2023, Judge McGlynn issued a ruling or an order rather that stayed our case for 90 days. So, essentially, on April 5th, he said, I want this case to be on pause until July 1st. And the reason that he stated for putting our case on pause was that he had four consolidated cases pending before him regarding the assault weapons ban or challenges to the assault weapons ban in Illinois. And he noted in his April 5th order, let's see, that there was a pending motion for preliminary injunction in those cases that he thought might apply or might impact our case, and he wanted to wait until he had made an order on that motion for preliminary injunction before moving forward with our case.
Cool. So, okay, what is a preliminary injunction?
So a preliminary injunction is essentially a when you apply for that, you're asking the court to stop a party from taking a specific action while your case is ongoing. So here, what the plaintiffs or the people challenging the assault weapons ban in Illinois were asking for was an injunction that would stop the state of Illinois from implementing or enforcing that assault weapons ban.
Cool. Okay. So, where do those cases currently sit?
So that's the exciting part is that on April 28th of this year, Judge McGlynn issued an order granting that motion for preliminary injunction as to those cases. So what he essentially did was he said, look, these plaintiffs, these people challenging the assault weapons ban have a high likelihood of succeeding on the merits. And that while the case is pending, they would be irreparably harmed if he didn't stop the state of Illinois from enforcing that ban. So he ended up granting that motion for preliminary injunction, therefore stopping Illinois from being able to enforce the assault weapons ban while the case proceeds. So it's important to note that this doesn't mean that the plaintiffs there have won. They haven't won. They still have to go through the full trial phase. It's not a final order, but it is definitely a good thing when a judge issues a preliminary injunction like that, because as I noted in the order, Judge McGlynn says that the reason he's granting this motion is that there's a likelihood that the plaintiffs will succeed on the merits once it's fully briefed and fully argued in his courtroom. And I'll say that the even more exciting part is that Judge McGlynn, as part of this order, ruled when he's talking about the assault weapons ban on flash suppressors and thumbhole stocks and pistol grips. He put in the order, quote, items that aid in accuracy may be considered arms and are presumptively protected by the Second Amendment. So we're pretty excited that same logic could be applied to our case challenging the suppressor ban in Illinois. Because as we all know, suppressors, while they have been defined by federal law since 1934 as a firearm, it's not the actual item that's going to project a projectile down the barrel, right? It's not a suppressor by itself isn't going to allow anyone to fire a round off. But there is a solid argument. We think that suppressors are protected by the Second Amendment, and Judge McGlynn, at least in terms of some other, similarly situated quote unquote accessories, thinks that those accessories could be considered arms and are presumptively protected by the Second Amendment. So we're very excited to be able to take that information and make the same argument and hope that he agrees with us that this should be applied to suppressors as well.
That's fantastic news. And I mean, you think about flash suppressors, like obviously that's one of the most common ways that suppressors are mounted to a host firearm. And none of those items are classified as firearms under federal law. The implications of that, of his preliminary injunction granting that, seem to be pretty huge.
They certainly could be. I don't want to get too excited quite yet. We've still got a lot of moving parts. And like I said, we're not going to There's likely to be no movement on our case prior to July 1st, the expiration of that 90-day stay. But it is certainly a very exciting argument to have at our disposal. And like I said, we think it's even stronger as applied to suppressors. And we're very excited to make that argument.
That's great. So what are next steps from here?
Well, we continue to wait. Like I said, nothing's going to happen before July 1st. But hopefully after that, we'll, in the meantime, we're conferring with attorneys and plaintiffs in this case to see how we can't make the best use of this order. And we've got some exciting decisions to make, and we're excited to keep you updated as we move forward.
Well, that's fantastic. And like Michael said, as soon as we have any more updates, we will keep everyone posted. Michael, anything else?
No, that's it. Thank you so much for having me on, Max.
Yeah, thank you very much for joining us. Stay tuned and we'll be back with more. As a nonprofit, our job is to fight for your rights, and we could not do it without your support. Your membership and your donations fund our fights in Washington, D.C. and in state capitals across the country. I promise that the American Suppressor Association will not stop fighting until suppressors are removed from the National Firearms Act and are legal to own in all 50 states. Help us protect your right to protect your hearing by making sure your membership in the American Suppressor Association is active. Visit us at asamember.com to join or renew today. That's asamember.com.